All right, so I'm going to take a moment to make a quick video, which I think might help other landlords and also give information to tenants. So what I'm doing today is giving the notice to the resident of their right, but not obligation, to request the initial walkthrough inspection. Now, what this is saying is that you have the right to request an initial walkthrough inspection from the landlord 2 weeks or sooner to the time that you move out. Now, not every tenant is going to want to do this. And if they don't do it, it's fine for the landlord, but it's really not in the best interest of the tenant to not opt for the initial inspection. They call it the initial inspection because this is inspection number 2. All right, the third one is after the move out, after the tenant moves out. That's when the landlord goes through the premises and finds all the damages that the tenant is going to be liable for. So in this case, it's after the first inspection, obviously, which is when the tenant moves in. We'll talk about that another time. That's very important for the tenant. That's when the tenant wants to mark everything as damaged. In this case, it's going to be the tenant and the landlord that go through, and the landlord will give the tenant the opportunity to do 2 things. Identify what deficiencies there are, in other words, damages that the premises has suffered under the tenant's tenancy. And secondly, the opportunity to have those damages repaired, replaced, cleaned. Now, not every type of damage is able to be repaired or replaced by the tenant. So that's something that the two will have to work out. Obviously, if the tenant is not qualified to repair drywall, then they're gonna have to hire somebody who is. And anytime you hire somebody, whether you're on the landlord side or the tenant side, make sure to save the receipts. Don't learn that the hard way. So if you're going to hire the drywall repairman, you're the landlord, then if the tenant, didn't fix that damage, then you have the right to hire the landlord, keep the receipts, and deduct it from the tenant security deposit. Conversely, if you're the tenant and you hire that drywall repair person to hire and fix your drywall, then the tenant should save the receipts, because if nothing else, that shows that you, the tenant, didn't repair the drywall yourself. You had a professional do it. And that's just one example. Obviously, you would do it for any electrical work that requires a licensed contractor. So the initial inspection must take place no earlier than 2 weeks prior to the termination of the tenancy. Now, landlords sometimes get that wrong. They think that, 2 weeks prior, 2 weeks or less, 2 weeks or sooner. That's sometimes vague. So they interpret it to mean I can do it anytime as long as it's not 2 weeks or sooner. And that's the exact opposite understanding. It has to be 2 weeks or sooner prior to the tenant's confirmed move out date. So before you do this, before you serve, and when I say serve, you shouldn't get freaked out if you're a tenant. This is not serving any kind of notice to quit. This is an informational notice that gives the tenant the right, but not the obligation, to request or decline the walkthrough inspection. And if the tenant says no, that's fine. They just have to do that on a written document, all right? So I'm going to hide the tenant's information here, but the tenant can check on the box, we want the initial inspection, or we decline the initial inspection. And also, we request the initial inspection, but I will not be present. The tenant does not need to be present there, but they don't even need the initial inspection at all. But if they don't go for it, then the landlord almost has carte blanche to find any defects in the premises and then subject the tenant to pay for them. It's going to be deducted from that tenant security deposit. So if you're a tenant, why wouldn't you want to avail yourself of that opportunity to identify any defects that are going to be deducted from security deposit, so you at least have an opportunity to cure some of them, or most of them, maybe even all of them. Next, after you've provided that notice, the next thing to do is wait for the tenant to work with you on the date and time if you can, but you're not obligated to. You should, in good faith, if you're the landlord, try to work with your tenant on figuring out a mutually agreeable date and time for that initial inspection. And normally, you're required to give a 24-hour notice to enter the premises, but in this case, for the initial inspection, it's another issue where landlords get tripped up. I don't know if this is an intentional act by the state legislature to play gotcha for landlords, but whatever their motivation is, it doesn't matter. The only thing that matters is that you as a landlord are expected to know the law, and if you don't, then you're gonna figure out what the law is in front of a judge, and don't learn the law as a defendant. All right, so we talked about the notice to request the initial walkthrough inspection. We talked about the tenant's right to request or decline the inspection, and they don't have to be present if they don't want to be. Let's say it's contentious with the landlord. Unfortunately, that is the case sometimes. That's fine, you don't have to be with the landlord during that initial walkthrough. But it's to your interest to do both, to have that initial walkthrough inspection and to be present so you can see how petty the landlord's being. And you can also see if the landlord is being dishonest and creating damage that otherwise wasn't there. And then, lastly, when it does become time to enter the premises for that initial walkthrough inspection, you're going to serve a notice on the tenant, and let me redact the tenant's information here. All right, so it'll be a 48-hour notice to enter the tenant's premises, and that will give the approximate day, well, the exact day, but the approximate time. It'll be the exact day on or about the time that you, the landlord, or your landlord's agent intends to enter the tenant's premises. So that does a couple things. Obviously, it gives the tenant, a heads up that we're going to be entering. So get ready. Don't, be in the shower. Don't be caught off guard. Next, it gives the tenant an opportunity to make some last minute cleaning and arrangements so the unit looks presentable. And you want to create, a good impression for that landlord as soon as they go in. Try to get rid of all the illegal pets and illegal paraphernalia that you have around the house. It would be a lot worse if the landlord just bombards on you. So we talked about landlord's right to offer the initial inspection, and it's an obligation actually for the landlord, but for the tenant it's a right but not an obligation to have that initial inspection conducted. And I strongly recommend, if you're a tenant, to avail yourself of that valuable opportunity so you're not surprised, as many tenants are when they don't request that initial inspection, how much the landlord is deducting from the security deposit. So if that tenant had been there, it would have helped that tenant, because the tenant could have gone through and recognized, no, this was there before. But that's why, going back to marking on that first of the 3 inspections, when you do that initial move-in inspection, that's why as a tenant you need to mark all the damage you find as abundantly as possible, because you need to figure that when it comes time for this second inspection, the initial inspection, also known as the pre-move-out inspection, your landlord is going to do the opposite. He or she is going to mark with abundance all of the damages that the landlord finds. And if you're not there to contest it, well, you're going to have to contest it possibly in court. Sometimes small claims, sometimes beyond small claims jurisdiction if it's more than $10,000 in damages, or the landlord is a corporation, etc. They can only sue for $5,000. So that could subject you to civil court. You don't want to have to deal with that. Do everything you can within your favor, within your power as a tenant. And if you found this video helpful, please let me know, and I'm happy to make more. Thank you.